How's it going? You know, it is after 5 o'clock today, and I have not been contacted by Kenneth Paxton. I have not been contacted by Greg Abbott, and I have not been contacted by John Cornyn, all of whom were alleged, at least, to be attorneys general here of Texas, and by law would have been required to approve any bond issued in Texas, including any bond that would have been in the name of Texas or any political subdivision in Texas. Now, there is more than one process that I am already apprised of, including through intercession with the comptroller, which the Attorney General has a very specific manner in which to engage, and including through other elements, including in association with the Texas Military Code, that could have been invoked or engaged in order for them to explicate the specific process they were going to follow through on in providing that audit. Thus far, none of them have contacted me. I have here this book. It is alleged to be an official publication on behalf of the Texas Senate, written by somebody identified as being an official story in the state of Texas. She was the coordinator of the actual publication for the state of Texas, recording the events of the Texas Senate secretary, and she also worked under the secretary of the Senate for a considerable amount of time. The particular version I have here also has a foreword by the former Lieutenant Governor William Hobby. It's a nice book, nice maroon with a gold seal of the state of Texas. And I'm looking here at this information on this page about a very important event you don't hear much about. See, I've been down south. Even down there, they didn't talk about this. It talks about a time in Texas history connected to a man named Henry Lawrence Kinney. He was born in Pennsylvania in 1814, came to Texas in 1838 after some time in Illinois. He is reputed to be the founder of Corpus Christi. I'll go there, huh? Not only that, it seems that in 1854 he went to Nicaragua. And while he was in Nicaragua, he also had some engagements in and with Honduras. Now, this is a very, very compelling story. I find what is here already to be substantial enough to merit further investigation, but what it lets me know is that somebody who officially served in the Texas Senate believed themselves to actually have an actual land claim in Honduras that they expected to be availed of the advantages of. As a matter of fact, they even put in here his discussion of how much money he expected to make from that land claim all the way back in 1854. Now, if you're from Texas, you know a little bit about history, how these things come up cyclically. That's one of these reasons why that process for that audit not being presented today by close of business Texas time, 5 o'clock, it's very disconcerting. See, the understanding was it was in performance of roles as Attorney General. One does not, I believe, get to assume an office later on and then say, well, everything I did before now is classified or confidential. You understand. No. Would this have been considered confidential? It's a history of the state of Texas. It's also the history of Nicaragua and Honduras. Who would have the right to say that's confidential information? So for that reason, there's a couple of things that we're going to have to take into consideration right now moving forward. I want to tell you right now that if at any point since the onset of the sunset review of the Texas Board of Medical Examiners, aka Texas Medical Board, or the Texas Bar Association, aka State Bar of Texas, that was set to occur during the 2017 legislative session term, if at any point since 2016, when that session began, up until now, if you have received a diagnosis as having a mental disability, I contend you may be available and you may be eligible for reconsideration of that diagnosis and potentially some sort of restitution in consideration of constitutional violations. In other words, your constitutional rights were violated. You see, there's another part of history very much about the current situation in Texas that could use a little context from down south. Anybody hear about what happened in 2015? There was a controversy involving the president of Honduras. Maybe you did. There was alleged to have been a journalist that did a sort of investigative report on the election campaign of then President Juan Orlando Hernandez. The allegations were that during his election campaign, he had been responsible for embezzling monies associated with the equivalent of the Social Security system in Honduras in order to benefit contributors to his election campaign. Now, at the time, the amount was assessed at $350 million American. $350 million has a different contextualization, including in American dollars in the United States, than it does in other countries like Honduras. But it's $350 million, that's a lot of money. Now, at the time, this journalist was arrested. He was charged with libel. They said that his accusations were a libel against the president of Honduras. And he actually spent some time in jail. You understand, libel's a serious charge. Did you know that in the state of Texas, libel is against the Constitution? The Bill of Rights of the state of Texas makes specific reference to rights associated with protection from acts of libel. As a matter of fact, under the Constitution of the state of Texas, Bill of Rights, Section 8, freedom of speech and press libel. Every person shall be at liberty to speak, write, or publish his opinions on any subject, being responsible for the abuse of that privilege, and no law shall ever be passed curtailing the liberty of speech or of the press, in prosecutions for the publication of papers, investigating the conduct of officers or men in public capacity, or when the matter published is proper for public information, the truth thereof may be given in evidence. And in all indictments for libels, the jury shall have the right to determine the law and the facts under the direction of the court, as in other cases. Now, in the state of Texas, there is a specific definition of libel, including in consideration of what an officer of the law would have to consider as the legal standard under the Civil Practice and Remedies Code regarding a liability and tort. Mind you, papers are very, very important when determining the tort, including determining whether or not that which would qualify in a civil jurisdiction would also be applicable in a criminal jurisdiction. Section 73.001, Elements of Libel. A libel is a defamation expressed in written or other graphic form that tends to blacken the memory of the dead, or that tends to injure a living person's reputation and thereby expose the person to public hatred, contempt or ridicule, or financial injury, or to impeach any person's honesty, integrity, virtue, or reputation, or to publish the natural defects of anyone and thereby expose the person to public hatred, ridicule, or financial injury. That's the legal definition here. That anybody that would contend that they understand and are responsible for application of the law should know or understand there's very, very significant matters included in this. This is a very, very serious charge. And it is a violation of the Bill of Rights, which takes precedence over any other legal consideration, including ones alleged to be violations of the Constitution, including violations of the Constitution that were allowed to be characterized as constitutional at a later point in time. I contend that there are many laws that have been passed in the last several years that do not meet constitutional muster, as they would say. They are not constitutional. They are an abuse of office, an abuse of the Constitution, and they are a libel against the people. But specifically libelous are cases where people were identified as having a mental disability, including in manners that refused to apply the appropriate legal standards associated with diagnosis, treatment, especially with prescription of medications or any requirements for treatment thereafter. Now, I've already addressed this formally in several contexts, including before the Supreme Court of Texas. I filed myself a petition for an in-bank review after being denied review by entities authorized by the legislature to review, as is constitutionally required, periodically certain commissions that were responsible for overseeing professional sectors in the state of Texas, hence the Texas Medical Board and the State Bar of Texas, which were under sunset review in 2017. During that time frame, the materials that were presented by the State Bar of Texas for consideration before the Sunset Review Commission included information that revealed that up until at least the end of 2014, when the statistics that were compiled in the information they submitted to the legislature were available, there had not been one prosecution overturning a diagnosis for mental illness in the state of Texas. Not one case had gone to trial to retract a diagnosis of being mentally ill. Now, you have to understand, anybody would understand, that is statistically impractical. But if you've actually had the experience of either being witness to what masquerades itself as mental health treatment, including in the diagnostic stages, or yourself have been subjected to an effort to try to compel you to accept a diagnosis as mentally ill, after some application of coercion has been applied, including in an effort to attempt to blackmail or extort you, including in efforts to try to compel you to agree to commit crimes or to cover up for crimes to which you've been witness, then I contend you've been libeled. They have diagnosed you specifically in order to make available to others your property, a lot of your property, and obligate it to illegal debt that violates the federal Constitution protections against illegal debt. It is a violation of your 14th Amendment at the least. And depending upon what they have done with it, it is also potentially a violation of other constitutional amendments on the federal level, as well as constitutional aspects here in the state of Texas, even prior to what was recently done. See, it would appear in early part of 2019, there was alleged to have been a judicial commission that was put together in the state of Texas. It was temporary. Understanding was that people that had had some problem with going through the mental health system could seek some sort of administrative redress. I contend that was a highly illegal process. It was attempting to try to compel people into a situation where they were required, against the law, to waive their right to any restitution in the event that it should become aware, or it should be brought to light later on, that there were serious, egregious violations of the Constitution and implications in very significant crimes associated with alleged mental health treatment. That was no such thing. Not only that, but by September 1st of 2019, several laws went into effect ostensibly concerning a mental health commission and other matters related to alleged mental health treatment. However, in consideration of other laws that went into effect impacting the financial situation in the state of Texas, I contend that these are highly illegal activities, and that what they are trying to do is literally traffic people under the auspices of being mentally ill in order to attempt to coerce them or compel them into agreeing to cooperate with crime, including high-level financial crime that they're attempting to obscure, and then put it under some rubric of confidentiality by passing laws that are completely unconstitutional, including in connection with contract bidding. That they're literally declaring people mentally ill so that they can traffic them as part of a contract bidding scheme that is, in effect, a form of kickback scheme that's been effectuated in addition to other manners, specifically by and through the office of the Attorney General. It goes on to this day, but it can stop, and it should stop. I have here a petition I submitted to the Supreme Court of Texas in 2018, June 29th, 2018. I attempted to have it appealed to, rather brought for review before the Supreme Court of the United States after it had been denied under misrepresentative context, and later the electronic record was changed to reflect terms that were not apparent and were not available at the time it was actually pending before the court. It was denied on the day that the state of Texas, presumably the state of Texas, presented a case to the Supreme Court under the auspices of some tax situation associated with the Affordable Care Act that itself was allowed to be reviewed by the Supreme Court of Texas. Well, the charges herein were not. But it brings up several matters. First of all, insofar as there may be a process right now where there is a demand, including a demand by somebody that understands themselves to have the authority of the federal district court and believes they are constitutionally authorized to say that they need recommendations on implementation of appropriate policy to handle people that are from a country outside of the United States and seeking to either immigrate or seek asylum within the United States, and in a context of understanding there are violations of the Constitution, including under executive order and in abrogation of what is currently legislation. And I do believe that that specific petition I have already submitted in 2018 outlines a process that I would recommend personally, and that I would recommend on behalf of the state of Texas with appropriate modifications insofar as other people would be available for consultation in order to refine it. And it's specifically explicated in the specific citations of law that are referenced as part of the authorities for the petition itself. But there are specific factors right now that I believe are of absolute relevance to the people of Texas, including, but especially anybody that has been libeled by a fraudulent misrepresentation as being mentally ill. I want to bring up, first of all, under the Texas Penal Code, Section 35.02, insurance fraud, the specific definition of insurance fraud. This is under the Penal Code. Now, under the Texas Insurance Code, there are specific requirements regarding production of documentation for authorization for medical treatment, including medical treatment provided by the state and or financed by the state. And I contend that also involve the intercession of state entities, including law enforcement entities, when it comes to transportation. The refusal to produce that documentation impacts the Texas Insurance Commission, which has a separate administrative process than any sort of judicial review that one would go through if they were invoking the Texas Penal Code. But by the letter of the law, I contend you may be eligible for consideration of criminal offenses in violation of considerations of insurance fraud under Section 35.02 of the Texas Penal Code. There's also the specific definition of theft under Section 31.03, theft. Let me make sure to cite this specific part. Appropriation of property is unlawful if the property is stolen and the actor appropriates the property knowing it was stolen by another, or property in the custody of any law enforcement agency was explicitly represented by any law enforcement agent to the actor as being stolen, and the actor appropriates the property believing it was stolen by another. That means there is a standard for understanding the acquisition of property, including property that has been stolen from somebody else, including somebody else that might have reported the property was stolen. Well, you didn't. It wasn't stolen. You lost it. It's a big difference. But the other thing that is important is Section 5. Property means A, real property. B, tangible or intangible personal property, including anything severed from land, or C, a document, including money, that represents or embodies anything of value. That is the legal definition of property under the Texas Penal Code. That is the legal definition of property that qualifies as or in consideration of offenses involving theft. Not only that, we also get in here to consideration of what it means to have to deal with matters related to expectations of accountability by government officials, which is part of what was identified earlier and that unfortunately was not responded to in the manner it needed to be by those alleging that they were attorney generals in the last three attorney generals of Texas, which is Section 531.1025, performance audits and coordination of audits. These are audits specifically connected to the Health and Human Services Agency for the state of Texas. Now, that is one process and procedure where there is a very specific relationship and requirement concerning audits regarding a specific authority with whom that audit is to be performed. Why? Because there is also a consideration of health risk assessments and who has the authority to authorize what happens with health risk assessments including with an understanding of how they were acquired. Which then brings up another thing that we need to be considering and that we will be addressing moving forward, which is, again, that section 503.005, health risk assessment under the Texas Health and Safety Code. But another factor that we are dealing with now, not specific and exclusive to considerations of mental health. Rather, section 161.061, laboratory information required. This is a specific element of the Public Health Code associated with immunizations that includes any kind of laboratory test. And what is required in regards to any kind of laboratory test, including any sort of laboratory test that would qualify as property. Now, these are the matters that are already on the record as having been put for consideration before the Supreme Court of Texas, and also requested for consideration by the Supreme Court of the United States prior to the onset of COVID-19, and also prior to changes to the state of Texas that are alleged to be constitutional that went into effect during the summer of 2019 and went into effect in September 1st of 2019, which also includes changes that went into effect on January 1st of 2020, which also includes changes that went into effect on January 1st of 2021, which also includes changes they allege are legal for implementation on January 1st of 2022, January 1st of 2023, January 1st of 2024, which means a failure to act now and every single day that one fails to act, you are preventing prevention. And it's not just about stopping what has already commenced, what has already been ongoing. It is part of a process that has a cyclical nature to it. Intervention in which is necessary to prevent against proliferation of and into further crimes. It's not one of those things where you could say, well, it already happened. I'm sorry, ma'am. I can't do anything about it. That is not true. It could have stopped today by 5 o'clock. We're going to stop it together.